Welcome, everyone, to the deep dive. Your shortcut, really, to getting your head around some complex topics.
Making you feel well informed.
Exactly. And today, we're diving into something that feels, well, absolutely fundamental, doesn't it? The right to freedom of thought, conscience, and religion.
Mm-hmm. Seems simple on the surface.
But, as we'll see, it's got this history kind of marked by conflict, and it's still a huge point of disagreement globally.
A real battleground in some ways.
Yeah. So we've pulled together insights from academic sources, and we really want to acknowledge the University of London for making some of this material available for educational purposes. This deep dive is also brought to you by Sinorbit Academy, Sri Lanka.
And a quick shout out to all the students listening, especially if you're gearing up for exams on this stuff. Best of luck from us.
Absolutely. Good luck. Okay, so our mission today, cut through the complexity.
Right. We want to unpack the actual legal protections, the international treaties, the regional ones,
Understand the history, those often tricky drafting debates.
and then see how courts actually apply these rights, especially when it comes to limitations and religious stress, which comes up a lot.
The goal is really to help you grasp the nuances, the disagreements, and why this right, even though it's ancient, feels so relevant today.
And the source material really gives us a great roadmap for this, doesn't it? Not just the dry text, but the stories behind the laws and what happens in court.
Perfect. So let's start way back, the history. Because states dealing with religious diversity, that's nothing new, is it?
Not at all. The sources point out that, long before we talked about human rights, rulers had to manage populations with different beliefs.
It was often practical, right?
Yeah.
Not about high-minded ideals.
Precisely. It was often about stability, avoiding conflict, insurgency, keep the empire running smoothly.
Yeah, the source mentions places like ancient Persia, Rome, the Mughal Empire, the Ottomans, the British Empire.
All grappling with this, they often found it easier or just necessary to accommodate different faiths to, well, avoid collapse. Pragmatism.
And we see specific examples. Early attempts at religious peace.
Yeah, definitely. Like the Edict of Milan, 313 CE. That was Emperor Constantine basically saying, okay, no more persecuting Christians in the Roman Empire. A big step.
Not total freedom for everyone, but significant.
Right. And later you get things like the Religious Peace of Augsburg in 1555. That was trying to calm things down between Catholic and Protestant princes in the Holy Roman Empire. Sort of a ruler decides the religion approach, but with some minority rights.
So these are examples of tolerance.
Yeah.
And the source makes a point of distinguishing this from respect.
Yeah, that's a really key distinction. Tolerance, it can sometimes imply the dominant group is just putting up with minorities, maybe conditionally.
Like we permit you.
Exactly. Modern human rights law aims for respect, which means acknowledging everyone's inherent dignity, equality, their autonomy to believe or not believe as just fundamental, deserving equal regard, not just like grudging permission.
That's a major shift in thinking. Okay, let's move from that history to the universal legal stuff. How does international law protect religious freedom today?
So the sources highlight two main avenues in universal treaties. First, protecting the actual right to believe, your inner thoughts, your conscience, the internal forum.
Okay.
Second, prohibiting discrimination based on religion or belief. And this discrimination aspect, it often weaves into the freedom discussion, as we'll see in the court cases.
And one thing that jumps out, which the source flags, is that unlike race, for instance, there isn't a single big international treaty just for religion.
Yeah, that's really telling, isn't it? It's a crucial piece of the puzzle. The history there is interesting. Back in 1962, the UN started work on drafts for declarations and maybe conventions on both race discrimination and religious intolerance.
Okay.
The race stuff moved relatively quickly. Declaration in 63, the Binding Race Convention in 1965, but the Declaration on Religion or Belief, that took until 1981. 16 years just to agree on the title and preamble for the declaration.
16 years. And a binding convention on religion just never happened.
It never materialized. And the source says the general view is still that the time isn't ripe for one.
Wow. That really signals how deep the disagreements run on this issue.
Absolutely. If states could agree on a binding treaty for race relatively early, but still can't for religion, it just shows you the persistent political, cultural, even theological sensitivities involved.
So if there's no dedicated convention, where do we find these universal protections? The source focuses mainly on two big ones, plus the Declaration.
Right. The Universal Declaration of Human Rights, the UDHR from 1948, not formally binding, but hugely influential.
A blueprint, kind of.
Exactly. Then the International Covenant on Civil and Political Rights, the ICCPR from 1966, that one is legally binding for states that ratify it.
Okay, UDHR, then ICCPR,
Yeah.
and then that 1981 declaration.
Yes, the Declaration on the Elimination of All Forms of Intolerance and of Discrimination Based on Religion or Belief. Non-binding, but it adds detail, especially on the discrimination angle.
Got it. Let's dive into the UDHR first. 1948. Where does religion pop up?
Well, Article 2 is the big non-discrimination clause right at the start. Rights apply without distinction of any kind, such as race, color, sex, language, religion. So it's there from the get-go.
Okay.
Article 16 mentions non-discrimination based on religion and marriage and family rights, though Article 2 kind of covers that anyway. Article 19 on freedom of opinion and expression is relevant too.
But the main one, the core provision for religious freedom in the UDHR, is Article 18. The source quotes it, and we should probably hear the exact words.
Definitely. UDHR Article 18 says, everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief, and freedom, either alone or in community with others and in public or private, to manifest his religion or belief in teaching, practice, worship, and observance.
Okay, let me repeat that key part.
Yeah.
This right includes freedom to change his religion or belief. Seems crystal clear.
It does, doesn't it?
But the source stresses that this exact phrase was a major point of contention during the drafting.
Oh, absolutely. Huge debate. The drafters, tried to sidestep some philosophical fights by not defining terms, but this one was just too fundamental.
What was the issue?
The source details the strong objections from the Saudi Arabian representative, Jamil Baroudi, and delegates from other Muslim-majority states. They were concerned that explicitly saying you have the right to change religion could be seen as endorsing conversion away from Islam, maybe even apostasy.
Which is treated very differently, sometimes severely, in some interpretations of Islamic law.
Exactly. So they saw it as potentially undermining their legal and social systems.
And the other side.
Well, delegates from, say, the U.S. and European countries argued that freedom to change your belief is essential. If you can't leave the religion you were born into or adopt a different one or none at all, is it really freedom of thought? They saw it as absolutely core to the whole idea.
A fundamental clash,
Yeah.
really. How do they resolve it in the UDHR text?
Well, the Saudi proposal to actually remove the explicit reference to changing religion was defeated, so the text stayed as we just read it.
But the source says they agreed on the words, but not really the meaning.
That's the crux of it. Little agreement as to what it actually meant. And the source points out that Saudi Arabia's objection specifically to Article 18 was a key reason why they abstained from the final vote on the whole UDHR.
So that lack of consensus on the right to change religion was baked in from the start, even with the agreed text.
Pretty much a classic example of international law papering over deep disagreements rather than resolving them. And these disagreements didn't just disappear after 48.
And UDHR Article 18 isn't absolute, right? There are limitations.
Correct. Article 29 of the UDHR sets out general limitations. Rights can be limited by law, but only to secure respect for others' rights and freedoms and meet the just requirements of morality, public order, and the general welfare in a democratic society.
So you can manifest your religion, but not if it harms others or seriously disrupts society, basically, provided the limits are fair and legal.
That's the gist. Okay, so that's the UDHR blueprint, highlighting that early, crucial debate. Now let's jump to the legally binding one, the ICCPR from 1966.
And the source says those same debates came roaring back. Negotiations were drawn out and difficult.
They certainly did, because now it was about creating binding law. The philosophical idea behind the ICCPR right is the individual as, rational, self-determining. From that view, choosing and changing beliefs is central, but getting all the states to agree, that was tough.
Okay, let's hear the text of ICCPR Article 18. The source gives all 4 paragraphs. We need to listen closely to the wording again, especially paragraph 1.
Right, here's ICCPR Article 18. 1. Everyone shall have the right to freedom of thought, conscience, and religion. This right shall include freedom to have or to adopt a religion or belief of his choice, and freedom, either individually or in community with others and in public or private, to manifest his religion or belief in worship, observance, practice, and teaching.
Okay, stop there for a sec. Paragraph 1. Instead of the UDHR's freedom to change, it's freedom to have or to adopt a religion or belief of his choice. That's the difference the source highlighted.
That's the key compromise wording. Very subtle, but hugely significant. It reflects that same deep disagreement. Some states worried change, encouraged proselytizing and conversion. Others insisted the right to change was fundamental.
So have or to adopt was ambiguous enough for everyone to sign on.
Exactly. Does adopt mean change or just adopt for the first time? It's open to interpretation. It allowed states to join the covenant while still holding different views on this really critical point. Let me repeat that key phrase. Freedom to have or to adopt a religion or belief of his choice. That's the ICCPR Article 18.1 wording.
So the core disagreement carried over, and the binding text still reflects that lack of full consensus on the right to change religion.
Precisely. And the source mentions that reservations some Islamic states entered to Article 18 reinforce this. Plus, Saudi Arabia, very active in the drafting, never actually joined the ICCPR. And if you compare ICCPR Article 18 to things like the Cairo Declaration on Human Rights in Islam or the original Arab Charter, they often lack that explicit right to change, though the revised Arab Charter gets closer but still avoids the change language.
Let's hear the rest of ICCPR Article 18, paragraphs 2, 3, and 4.
Okay. 2. No one shall be subject to coercion which would impair his freedom to have or to adopt a religion or belief of his choice. 3. Freedom to manifest one's religion or beliefs may be subject only to such limitations as are prescribed by law and are necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. 4. The states parties to the present covenant undertake to have respect for the liberty of parents and, when applicable, legal guardians to ensure the religious and moral education of their children in conformity with their own convictions.
Okay, so paragraph 2 prohibits coercion. Paragraph 3 lists the limitations on manifestation, and paragraph 4 covers parents' rights regarding children's religious education.
Correct. And that list of limitations in paragraph 3 is really important.
Before we get to the limitations, are there other relevant ICCPR articles?
Yes, Article 2 is the non-discrimination clause, similar to the UDHRs. Article 24 protects children without discrimination based on religion, and then there's Article 26.
Article 26. The source says this one is particularly important.
It is. It's the general freestanding non-discrimination clause. It prohibits discrimination on various grounds, including religion, across the board.
Freestanding means it applies generally, not just tied to another specific right in the covenant.
Exactly. It's a broad protection against discrimination. And the source points out this contrasts with the European Convention's approach, which we'll get to. So Article 26 ICCPR is the key freestanding non-discrimination clause, including religion. Definitely remember that distinction.
Okay, now back to Article 18 itself. The source highlights a couple of other really noteworthy aspects. One is about emergencies.
Yes, this is huge. ICCPR Article 18 is non-derogable, meaning states cannot suspend or limit the core right to freedom of thought, conscience, and religion, even in a time of public emergency that threatens the life of the nation. Under Article 4 of the ICCPR, states can derogate from many rights in emergencies, but Article 18 is one of the very few they absolutely cannot touch.
Wow, that really underscores its fundamental importance in the ICCPR system. Remember, ICCPR Article 18 is non-derogable.
It absolutely does.
Okay, and the limitations again, in Article 18.3, the source stresses they are strict.
Very strict. And crucially, they only apply to the manifestation of religion or belief, the external practice. The internal freedom of thought, conscience, religion itself, that's absolute, cannot be limited.
And the grounds for limiting manifestation are only those specific ones listed.
Yes, it's an exhaustive, closed list in Article 18.3, prescribed by law and necessary to protect public safety, order, health, or morals, or the fundamental rights and freedoms of others. Let's repeat those grounds. Public safety, order, health, morals, or fundamental rights, freedoms of others.
And the source points out this list is tighter than for other rights, like no national security.
Exactly. National security is a ground for limiting, say, freedom of expression, Article 19, or assembly, Article 21, but not for limiting religious manifestation under Article 18.3. That's deliberate.
And limitations are only for fundamental rights of others.
Yes, not just any rights. And the tests are strict. Must be prescribed by law, genuinely necessary, directly related to one of those grounds, proportionate, and non-discriminatory. The source also adds that morals shouldn't be interpreted based only on one single tradition. The strict interpretation of Article 18.3 limitations is a key point.
The source also mentions the HRC's General Comment Note 22 as being important for understanding Article 18.
Yes, General Comment 22 is the Human Rights Committee's official interpretation. It's crucial. It takes a very broad view of belief and religion.
How broad?
GC 22 says Article 18 protects theistic, non-theistic, and atheistic beliefs, and the right not to profess any belief at all. It's not limited to traditional religions. The committee was concerned about discrimination against new or minority religions, so Belief and religion under Article 18 are broadly construed.
And how does GC22 describe the manifestation part? What counts as manifesting your belief?
Paragraph 3 of GC22 gives a wide range of examples. Worship, like rituals, building places of worship, symbols, holidays. Observance and practice, like diet rules, wearing distinctive clothing or head coverings. Life rituals, language. Teaching, like choosing leaders, schools, distributing texts. It covers a lot, public or private, alone or in community. That specific example is worth repeating. Wearing distinctive clothing or head coverings is explicitly listed by GC22 as a specific example of manifestation.
Does GC22 say anything about the right to change debate, given the have or adopt wording?
It does. Paragraph 5 confirms the committee's view. Have or to adopt means freedom to choose, including changing your beliefs, adopting atheism, or keeping your current beliefs. It interprets Article 18.2 on coercion broadly, too, not just physical force, but also policies or practices with the same effect,
What kind of policies?
like restricting access to education, medical care, employment, or political rights, Article 25 rights, because of someone's beliefs or lack thereof. GC22 says these can be inconsistent with Article 18.2 as coercion. So, restricting access to education or employment due to religious manifestation can be seen as coercion under Article 18.2, according to the HRC.
And GC22 reinforces the strictness of the Article 18 limitations.
Absolutely. Paragraph 8 repeats. Only manifestation can be limited only on the specific 18.3 grounds interpreted strictly, must be necessary, proportionate, non-discriminatory. The strict interpretation of Article 18.3 limitations, as detailed in GC22, is critical.
Interestingly, the source notes that GC22 seems very focused on non-discrimination, maybe even more than the freedom aspect itself.
That's a subtle critique, yeah. That the committee often approaches Article 18, which is about freedom, through the lens of non-discrimination, kind of compounds the two concepts.
Okay, let's pivot from the universal framework to the regional systems. The source says, maybe surprisingly, that negotiating these regional treaties was sometimes easier.
Perhaps because the states involved were often more similar, or they just made pragmatic choices to avoid the deepest philosophical fights. They often deliberately avoided defining religion or belief, and they tended to focus narrowly on thought, conscience, expression, and non-discrimination.
Let's start with Europe. The European Convention on Human Rights, ECHR, Article 9.
Right. Article 9.1, the main part, was apparently drafted quite easily, closely following the UDHR. The source quotes it. Everyone has the right to freedom of thought, conscience, and religion. This right includes freedom to change his religion or belief in freedom, either alone or in community with others and in public or private, to manifest his religion or belief in worship, teaching, practice, and observance.
So like the UDHR, the ECHR explicitly includes the freedom to change religion. That's a clear difference from the ICCPR's have or adopt. Remember, ECHR Article 9.1 explicitly includes the freedom to change religion.
A very important difference.
What about limitations, Article 9.2?
The grounds are similar to the ICCPR, prescribed by law and necessary in a democratic society for public safety, public order, health, or morals, or protecting the rights and freedoms of others. But the source notes a small difference. It just says rights and freedoms of others, not fundamental rights and freedoms like the ICCPR, maybe slightly broader.
Potentially. And another big difference from the ICCPR regarding emergencies.
Yes, a major one. Unlike the non-derogable ICCPR Article 18, ECHR Article 9 can be derogated from in times of war or emergency under ECHR Article 15. This applies to both holding beliefs and manifestation. Remember, ECHR Article 9 is derogable, unlike ICCPR Article 18. That's a crucial distinction between the two systems.
And non-discrimination in the ECHR.
That's Article 14. It prohibits discrimination, including on religious grounds, but only in relation to the other rights guaranteed by the Convention. It's not freestanding like ICCPR Article 26. It has to be linked to another ECHR right.
So you can't just claim discrimination under Article 14 on its own?
Not usually, no. There is Protocol 12, which does provide a freestanding right, but it hasn't been ratified by all ECHR states, though it is in force for those that have. So remember, ECHR Article 14 is not freestanding, unlike ICCPR Article 26.
Okay, so the ECHR, clear on changing religion, potentially slightly broader limits, and it's derogable. Interesting. Now, the Inter-American System.
Two main documents there. The American Declaration of Rights and Duties of Man, 1948, and the American Convention on Human Rights, 1969. The Declaration's Article 3 is pretty concise. Right to freely profess, manifest, and practice religion, public or private.
And the American Convention.
Article 1 is the non-discrimination clause. Article 12 is the main religious freedom one. The source suggests maybe greater cultural similarity in the Americas help them agree more easily than at the global level.
Let's hear Article 12 of the American Convention.
Okay, Article 12 says, 1. Everyone has the right to freedom of conscience and of religion. This right includes freedom to maintain or to change one's religion or beliefs, and freedom to profess or disseminate one's religion or beliefs, either individually or together with others, in public or in private.
Okay, paragraph 1 again. Freedom to maintain or to change one's religion or beliefs.
Yeah.
The source really emphasizes this, like the ECHR, but maybe even more direct than the ICCPR compromise.
Exactly. The source makes a big point that the American Convention expressly recognizes the right to change religion. No ambiguity like the ICCPRs have or adopt. It seems the consensus was stronger there on this point. Remember, the American Convention expressly recognizes the right to change religion.
What about the rest of Article 12?
Paragraph 2 prohibits restrictions impairing the freedom to maintain or change beliefs. Paragraph 3 lists limitations on manifestation prescribed by law, necessary for public safety, order, health, morals, or rights freedoms of others, similar to ICCPR. And paragraph 4 covers parents' rights for children's religious education.
Got it. Okay, finally, the African Union System. The African Charter on Human and People's Rights.
Right. Article 2 is the non-discrimination clause. Article 8 is the specific religious freedom one, and the source notes it's the shortest binding provision we're looking at.
What does Article 8 say?
It says, freedom of conscience, the profession and free practice of religion shall be guaranteed. No one may, subject to law and order, be submitted to measures restricting the exercise of these freedoms. Remember, this is African Charter Article 8.
Subject to law and order. Whoa, that sounds really broad compared to the detailed lists in the ICCPR or ECHR.
It is. The source calls it the least stringent limitation clause discussed. It's seen as a pragmatic political compromise given the huge diversity of states in the African Union.
The lowest common denominator, perhaps.
Possibly. It reflected the need to get agreement across very different contexts.
And the source notes there's not much case law interpreting Article 8 yet.
Right. The African court hasn't really had cases digging into Article 8, so how strictly that subject to law and order limitation will be interpreted in practice is still largely an open question.
Okay, so recapping the regional picture. ECHR and American Convention explicitly include the right to change religion. African Charter doesn't mention it. Limitation clauses vary hugely from the strict ICCPR list through the each American ones, down to the very broad African law and order. And ECHR is derogable, ICCPR isn't. Really highlights the different approaches.
Absolutely. These aren't just academic points. They matter on the ground.
Right. So now let's get practical. How have courts actually applied these rights, particularly regarding manifestation and limitations? The source focuses on the Human Rights Committee, HRC, for the ICCPR, and the European Court of Human Rights, ECDHR, for the ECHR.
Yeah, because there isn't much jurisprudence yet from the African or inter-American courts on this specific topic, especially religious dress. These cases show how the principles get tested in real life.
Let's start with the HRC. The source says, maybe surprisingly, there isn't a huge volume of cases decided on Article 18.
True, many petitions get declared inadmissible, but we have their general comment number 22 as the baseline.
Right. GC 22. Remind us of the key points from that again.
Broad definition of belief and religion, including non-theistic and atheistic, broad range of manifestations, specifically including wearing distinctive clothing, confirmation that have or adopt covers the right to change belief, and a strict interpretation of the limitations in Article 18.3 only for manifestation, only on listed grounds, must be necessary and proportionate. And Article 18.2 on coercion covers policies restricting access to education or employment.
Okay, got it. Now, the specific HRC cases. First, an early one, Karnal Singh Binder v. Canada from 1989.
Right, Binder v. Canada. The applicant was Karnal Singh Binder, a Sikh man working for the Canadian federal government. His religion required a turban. His job required a hard hat for safety.
The classic turban versus hard hat scenario.
Exactly. He refused the hard hat, lost his job, and claimed violations of ICCPR Article 18 and Article 26, non-discrimination. Remember the case name. Binder v. Canada, and the facts. Sikh worker, turban versus hard hat, job termination.
And the HRC's decision.
They looked at both articles. They said the hard hat rule was a limitation on his Article 18 right to manifest, but it was justified under Article 18.3 for public safety. They also said it was reasonable under Article 26.
But the source critiques this reasoning. calls it deeply unsatisfactory.
It does. The criticism is the committee didn't really explain how it balanced the rights or applied the necessity test, and it didn't clarify how the Article 18 and Article 26 analyses related to each other. It feels a bit thin, especially compared to the later detail in GC 22, which specifically mentions head coverings as manifestation.
Okay, moving on. The next HRC case is Reyhan Hudoy-Berganova v. Uzbekistan, decided after GC 22.
Hudoy-Berganova v. Uzbekistan. The applicant was Reyhan Hudoy-Berganova, a student. She was kicked out of university for wearing a hijab because of a state rule banning religious dress in public places like universities. She argued this violated Article 18, remember the case name? Hudoy-Berganova v. Uzbekistan, and the facts. Hijab ban, exclusion from university.
What did the HRC find?
They found Uzbekistan had violated her Article 18 rights. Their reasoning focused on Article 18.2, the coercion clause. They said preventing her from manifesting her religion by wearing the hijab, and specifically linking it to her exclusion from education, amounted to coercion, impairing her freedom to have or adopt a belief.
They explicitly linked it back to GC 22.
Yes, to paragraph 5 of GC 22, which says restricting access to education can be coercion under Article 18.2.
Did Uzbekistan try to justify the ban under the Article 18.3 limitations, like public order or safety?
Apparently not. The source says they just argued she broke the rule, so the HRC focused on the coercion aspect.
But the source suggests maybe they should have tackled the Article 18.3 limitations more directly.
Yeah, the critique is that relying on Article 18.2 kind of sidestepped the harder question. Could a general ban on religious dress in public ever meet the strict necessity and proportionality tests of Article 18.3? The committee acknowledged context matters, hinted at a margin of appreciation, but the source argues any margin should be very narrow for a non-derogable right like Article 18.
Okay. And finally, the HRC cases on the French face veil ban, Yacker v. France and Hebet v. France from 2018.
Right, these dealt with the 2010 French law banning concealment of the face in public. This effectively bans the niqab and burqa. The applicants, Ms. Yacker and Mrs. Hebet, were fined under this law and argued it violated their rights, including Article 18. The HRC looked at them together, remember the case names, Yacker v. France and Hebet v. France, and the facts challenging the French niqab burqa ban after being fined.
And the HRC's conclusion on the French ban.
They found France had violated their human rights under Article 18 ICCPR. The committee decided the general ban disproportionately harmed their right to manifest their religious beliefs. They weren't convinced France had shown the ban was actually necessary.
What about France's justifications? Public safety. Living together.
France argued both. For safety, the HRC said, well, you can require face showing for specific ID checks, but a total ban everywhere is too broad. For living together, the HRC basically questioned if the ban was proportionate, suggesting it could actually harm integration by isolating women.
So the HRC rejected France's arguments.
Pretty much. They weren't persuaded the ban met the strict requirements of Article 18.3. The source notes the committee was careful not to judge the veil itself, just the state's action in banning it generally.
And the source stresses we need to compare this outcome directly with the European Court's decision on the same law.
Absolutely. The HRC finding a violation here must be contrasted with the ECTHR's judgment in SAC France. This contrast between the HRC and ECTHR on the French ban is a really key point.
Okay, let's switch to the European Court of Human Rights, ECTHR then. Article 9 cases. The source says these have really increased since the first big one in 1993.
Yes, hugely. And that first key judgment was Kokkinakis v. Greece.
Tell us about Kokkinakis.
The applicant was Mr. Kokkinakis, a Jehovah's Witness in Greece. He kept getting arrested and convicted under Greek law for proselytism, trying to convert people by talking about his faith, handing out literature. He argued this violated his Article 9 rights. Remember the case name, Kokkinakis v. Greece, and the facts. Jehovah's Witness convicted for proselytizing.
What principles did the ECTHR set out in Kokkinakis?
Some really foundational ones. Religious freedom is a basis of a democratic society, vital for pluralism. It includes manifesting belief, bearing witness in words and deeds. And crucially, manifestation includes the right to try to convince one's neighbor, proselytism. Without that, the right to change religion is hollow. The source explicitly repeats that the ECTHR included proselytism as a protected manifestation.
And limitations under Article 9 too.
The court said limitations only apply to manifestation, and acknowledged that in diverse societies, some restrictions might be needed to reconcile different groups' interests.
Why did the court find a violation in Kokkinakis' case?
They agreed Greece had a legitimate aim protecting others from improper proselytism. But they found the way the Greek courts convicted him wasn't proportionate to that aim. so it wasn't necessary in a democratic society.
But the source raises critiques here, too.
Yes. While the court accepted proselytism is protected, it also introduced this idea of improper proselytism without really defining it clearly. How do you balance the rights? The source also notes Article 9.2's ground of rights and freedoms of others is quite vague compared to the ICCPR's fundamental rights and freedoms, possibly giving states too much leeway. The critique of vagueness in Kokkinakis regarding improper proselytism and the broad limitation ground is noted.
Okay, next ECTHR case.
Yeah.
Dalab v. Switzerland from 2001. The source says this one had controversial reasoning.
Very controversial. The applicant was Miss Dalab, a primary school teacher in Switzerland who converted to Islam. She started wearing a headscarf at school. This was deemed against the education rules focused on neutrality. Swiss courts upheld the ban. She went to the ECPHR. Her application was ultimately inadmissible, but the reasoning is what matters. Remember the case name, Dalab v. Switzerland, and the facts. Teacher banned from wearing a headscarf in primary school.
What was that reasoning?
The court accepted the ban was lawful and pursued legitimate aims, protecting others' rights, public order. Then came the necessary in a democratic society test involving the state's margin of appreciation. The court sided with the Swiss view, weighing her role as a state representative needing neutrality against her freedom.
And the controversial part.
This is where the court talked about the potential impact of a powerful external symbol, like a headscarf, on very young children, 4 to 8 years old. It mentioned the difficulty in assessing its proselytizing effect. Then, it controversially linked the headscarf to a Quranic precept that it suggested was hard to square with the principle of gender equality. It basically questioned if the symbol was compatible with the message of tolerance and equality teachers should convey. The source highlights and quotes this controversial reasoning on passive proselytizing and linking the headscarf to gender inequality.
And based on that, the court found the ban not unreasonable within the state's margin, making the claim inadmissible.
Exactly. And the source is highly critical. No evidence of actual proselytizing. Criticizes the court for speculating about the headscarf and gender equality, and crucially, for failing to give weight to Mrs. Dalab's own choice and autonomy in converting and wearing it. It sees Dalab as showing too much deference to the state. These critiques of Dalab's reasoning are important.
Then came Leyla Şahin v. Turkey, a 2005 Grand Chamber judgment.
Yes, Şahin v. Turkey. Involved Leyla Şahin, a medical student banned from Istanbul University for wearing a headscarf due to university rules enforcing secularism. Remember the case name. Leyla Şahin v. Turkey and the facts. University headscarf ban for a medical student in Turkey.
And the Grand Chamber's finding.
They found no violation of Article 9.
How did they justify upholding the university ban?
They said the interference was justified and proportionate, therefore necessary. They leaned heavily on Turkish constitutional court rulings that saw the headscarf as incompatible with Turkey's constitutional principles, especially secularism.
What were the specific legitimate aims accepted?
Protecting others' rights and public order. But the underlying values the court focused on were secularism and equality. The ban aimed to preserve the university's secular nature, prevent pressure on other students, and promote gender equality within that context. Remember, secularism and equality were accepted by the court as specific justifications for the ban in Şahin. The source sees this case as reflecting the Turkish state's specific commitment to secularism and the court deferring to that.
Okay, finally, the big one that contrasts with the HRC. SSV France, 2014 Grand Chamber. The French face veil ban again.
Exactly. The same 2010 law. The applicant was SS, a French woman who wore the niqab sometimes for spiritual reasons, willing to remove it for ID checks. She challenged the law under Article 9 and Article 8, private life, personal appearance. Remember the case name? SS v. France and the facts. Challenging the French law banning face concealment. Niqab burqa ban.
What were France's arguments this time?
Two main ones: public safety, identification, and second, ensuring respect for the minimum values of an open and democratic society, which included gender equality, human dignity, and this concept of living together, le vivre ensemble, social harmony through open interaction. These were France's stated justifications.
And the ECTHR's finding insists.
Okay, this is complex. They found the ban was not necessary for public safety, less restrictive means exist. But T, focusing on the second aim, they latched onto living together as the key justification. They decided defining how living together works falls within a wide margin of appreciation for the state. And based on that wide margin, they concluded there was no violation of the convention. Remember the outcome. No violation found, justified primarily by living together, and the grant of a wide margin of appreciation to France.
But the source highlights an important positive shift in SAS compared to Dalab and Xing.
Yes, absolutely. The court explicitly backed away from using gender equality as a reason to ban a practice women choose to follow. They basically said states can't impose their view of equality to stop women exercising their rights freely unless it's about protecting them from coercion. They acknowledge religious dress can be part of identity and pluralism. This positive shift in SAS, rejecting gender equality as a general justification and emphasizing applicant autonomy, is a key point and addresses earlier critiques.
So, more respect for the woman's own choice and autonomy, correcting the patronizing tone of earlier cases.
Exactly. The court didn't try to interpret the meaning of her veil. It acknowledged the potential harm the ban could cause Muslim women, a definite improvement in tone and reasoning on that point.
But the ban was still upheld,
Hmm.
based on living together.
Yes. The court accepted this abstract idea of living together as falling under the protection of the rights and freedoms of others limitation in Article 9.2, even though living together isn't explicitly listed there. The logic was that the face veil hinders the open social interaction needed for this concept. Remember, living together was accepted as a limitation ground via the court's interpretation of rights and freedoms of others in Article 9.2.
Living together sounds very open to interpretation.
It is. The court acknowledged the risk of abuse and promised a careful examination. But the source argues they didn't do that because they immediately granted France a wide margin of appreciation.
And the source is critical of giving a wide margin here.
Yes, strongly critical. Especially because the court knew about the context of Islamophobia and prejudice against veiled women in France. For such a vulnerable group, the source argues, a truly careful examination should have meant a narrower margin, not a wide one. Giving a wide margin seems inconsistent with protecting minority rights effectively. The critique of the living together ground and the grant of a wide margin of appreciation in SAS, especially given the context of known prejudice, is a central point.
So why do they find the ban proportionate then?
The court gave a few reasons, which the source critiques. 1, the ban was only on the face veil, not all religious dress. 2, only a small number wore it. Critique ignores impact on that group. 3, penalties weren't severe. Critique doesn't justify disproportionate ban. 4, overarching reason, the wide margin of appreciation, deferring to France's democratic choice. Critique contradicts careful examination.
So, summing up the ECTHR trend, AS has improved on Dalab regarding gender equality and autonomy, but introduced this contested living together ground and upheld the ban with a wide margin, leading to a direct conflict with the HRC.
Exactly. HRC found the French law violated ICCPR Article 18, Yekkerhebij. ECTHR found it did not violate ECHR Article 9, SAS.
France is caught in the middle.
Legally, yes. To comply with both, they'd need to repeal the law, which seems unlikely. It shows the real-world clash between different interpretations. And other European countries have similar laws, or are considering them. The conflict between the HRC and ECTHR judgments on the French ban and the resulting situation for France is a critical takeaway.
So thinking about Dalab, Shaheen, and SS, has the European approach been consistent towards Muslim women's religious freedom?
Based on the source's analysis, no, not really consistent in reasoning. Essays changed the game by rejecting the gender equality argument used before, which was a big shift. But the outcome, allowing restrictions bans, remains similar, just justified differently using living together. So evolving, yes. Consistent, not so much.
And does this focus on religious dress, especially for Muslim women, make it seem like a battleground for bigger societal debates in Europe?
The source definitely frames it that way. These court cases become arenas where societies wrestle with secularism, multiculturalism, integration, individual rights versus collective norms. Visible religious symbols, particularly the hijab or niqab, have become flashpoints for these wider tensions.
Okay, stepping back again, it's clear religious freedom, while fundamental in principle, is really contested territory in practice.
Absolutely. The source circles back to this. The idea isn't controversial, but it's caught up in geopolitics, cultural clashes. Those drafting debates, especially on the right to change religion, show the deep divisions.
And that lack of full agreement on its scope, does it cover proselytizing? Changing faith means it hasn't achieved that top-tier status in international law, like just Cogent's norms.
Correct. And there's still so much debate about limitations. When and how can manifestation be restricted?
Plus, as we've seen in detail, different courts, the HRC and ECTHR, take different approaches.
Yes, and even the ECTHR's approach has evolved, grappling with secularism, multiculturalism, gender equality. SAS showed a shift, even if the outcome was controversial.
Right. What a journey. From ancient tolerance to modern respect, through the specific treaty articles, UDHR, ICCPR, the Declaration, ECHR, American Convention, African Charter, highlighting those tough drafting debates, especially the right to change religion. And then diving into the court cases, HRC and ECTHR, seeing how they handle limitations, especially on religious stress, showing those different evolving and sometimes conflicting approaches.
It really shows that even fundamental rights are constantly being interpreted and reinterpreted in light of new challenges.
So here's a final thought for you, our listeners, to chew on, drawing from everything we've discussed. Considering the history, the lack of full consensus on scope, the arguments over limitations, the different court approaches, especially in those tough religious dress cases where societal values clash, is the right to freedom of religion, despite being historically ancient and philosophically central to autonomy, truly a central and universally agreed upon right in practice today? Or is it still very much a work in progress, maybe even losing ground in some areas? Something to think about.
A really important question for reflection.
Thank you so much for joining us on this deep dive. We hope you feel much more informed now. And again, good luck to all students with your exams. Keep exploring these vital human rights issues.